Greetings, class. This is Professor McKenzie again. Welcome back. Today, we're in Business Law 1. We're going to be looking at Chapter 8, which is our Introduction to Contract Law. We're going to be looking over the next couple of weeks in great detail different facets of elements of contracts. The ultimate goal being is that we want to make sure that the agreement we have crafted translates into what is called an enforceable agreement. We'll go through and I'll kind of remind you kind of each step along the way that for any contract that you enter into, you want to make sure that you've satisfied all the core elements, because by doing so, then you're going to ensure that you have an enforceable agreement. So if the other side or the other party doesn't perform as promised, you can go into a court and reliably, kind of like know that the agreement, because it's enforceable, the judge then will render a decision that will be favorable for your position and compel the other side to either do what they promised or compute some kind of range of damages, which we'll get to, over the next couple of weeks. Anyway, that's big picture. As we kind of go through probably the next like 5 or 6 chapters, we're going to be looking at in great detail different facets of contracts. So for this chapter, though, it's just a very base introduction. I want us to understand how and why contract law has developed. We'll talk about what a contract is, what topics will be discussed in the contracts chapters of this course, the sources of contract law, and then how contracts are classified. So that's big picture learning objectives that we're going to be getting to in this initial chapter. So the definition of a contract is that it is a binding, and when I say binding, I mean an enforceable agreement that either is between two or maybe among two, 3 or more parties, and the required elements that are necessary. And again, we're going to go through these, over a few weeks. So I'm going to make sure that by the end of this series of chapters, you have a very good, solid foundation and understanding of what it takes to have an enforceable agreement. So in terms of its component parts, so you have, you feel like, okay, I have a contract. You've got to be able to demonstrate these specific elements in a court of law if you want that document or that agreement to be determined to be enforceable. So I'll kind of walk you through these. There has to be an offer, there has to be an acceptance, there has to be consideration. The nature of the contract has to involve lawful subject matter, and the parties to the agreement have to have at the time of the agreement what is referred to as legal capacity. And so we're going to go into a lot more detail for each one of those elements, but at least initially, in terms of our exploration of binding contracts, just know you have to satisfy each one of these. If any of you are fans of mathematics, I'm not really a big fan of mathematics. I mean, it's challenging. I kind of enjoy the challenge, but I remember when I had college algebra, and if you remember, sometimes you would be given a problem to solve, and it would be like, A plus B plus C. There's some variable that you have to figure out, and then that equals whatever the answer is. So I think of contracts like that. It's like, well, you have to have, this like offer. That's like, this plus an acceptance, plus mutual consideration, plus lawful subject matter, plus legal capacity. And if you can check all those boxes off, then you have a binding, enforceable contract. So sometimes depending on like the source or the textbook or the website that you're looking at, when they're discussing what it takes to form a contract, sometimes there's this label called mutual assent, and usually mutual assent is the blending together of the offer and the acceptance. And so don't get confused if you see that in some other source, if you're looking up different topics involving contract law. But you do have to have all of those specific elements. So I always like to try and go through examples. I try and make it more approachable and have it make more sense from your perspective as the student. And so for me, one example that comes to mind is the grocery store. I think all of us have had the experience where you walk into a grocery store and, your purpose there is to buy whatever you need, for sustenance, and then you leave. So, everything on the shelf is an offer. whether you realize that or not. It could be a gallon of milk, it could be a loaf of bread, it could be bananas, it could be frozen dinners, it could be soup, whatever it is that is on the shelf. That is an offer. And so the grocery store is basically saying, hey, do you want to buy this? This is our offer. Your acceptance is when you grab it and you put it in the basket or your cart or your bag, whatever you use to carry your groceries around with as you shop. That's your kind of acknowledgement that, okay, I accept your offer, and so that's the acceptance component to it. Technically, before you get to the register, you could put something back, and I've done that, and I'm sure many of you have done that, where you just kind of change your mind. And so, even though when you initially pick it up, maybe the best way to describe that is a conditional acceptance. For our purposes, we're just going to say that, when you put it in the basket, that's acceptance. Mutual consideration. The idea with mutual consideration is that each party to a contract has to give up something of value in exchange for something of value. So again, sticking with the grocery store example. So, let's say that I go to the grocery store and I have a basket full of, different items. I've got milk, bread, eggs, cheese, normal stuff that I buy as part of my weekly groceries. And when I go to the cash register, the person who's operating the cash register, he or she, they ring everything through and it gets bagged. At some point, that is complete. And then I am told this is what your total is. And so for me, my consideration, what I'm giving up is whatever the form of payment is. So I might have cash, it might be a personal check, it might be a debit card, it could be a credit card, whatever. I'm basically giving up currency of some kind in exchange for what I'm trying to acquire, which is food. The consideration that the grocery store is giving up, obviously, is inventory. They're giving up inventory because they would rather have cash. I'm giving up cash because I would rather have food. I can't eat cash. So that's the mutual consideration. We are both in this exchange, we're giving up something of value to get something back that we perceive to be of comparable value. That's really the heart of what mutual consideration is. The lawful subject matter, obviously, whatever you're purchasing and selling has to be legal. So, I'm sure like in the world of, illegal activities, where people are buying and selling, it could be stolen merchandise, drugs, whatever. I'm sure there's offer, acceptance, consideration, capacity. But obviously, courts are not going to enforce an illegal agreement. But in the grocery store example, it's legal because, as far as I know, it's still legal to buy milk, bread, eggs, all that stuff. So that's not a problem. And then capacity goes to the mental state of the parties to an agreement. Do they both understand the nature of what they have entered into? Do they understand that there are rights and obligations that flow in both directions when it comes to the creation, formation, and execution of a contract? So if you can check all those boxes off, then once you've completed the transaction, you have completed the contractual obligation. So the grocery store example, as soon as I'm told how much my groceries cost, they've been bagged. I pay the cashier. He or she, gives me the receipt. I get handed the bag of groceries. At that point, the contract has been completed. And that's what I want you to kind of realize is that contracts are not just these big things where you're purchasing a car and you're making payments for 60 months, or you're buying a home and you've got a mortgage for 20 or 30 years. Obviously, those are contracts as well. But you and I, as just average persons, we enter into contracts virtually every day of our lives, and they're usually very minor in the scheme of things. It could be going to the grocery store. It could be filling up your vehicle with gas, So whatever the transaction is, always be thinking, well, what's the offer? What's the acceptance? What's the mutual consideration that's flowing in both directions? We're presuming that it's a lawful subject matter and that the parties that are involved have what is considered to be legal capacity. Now, upcoming chapters, we're going to have a chapter that deals with just offers and just acceptance and just consideration and lawful subject matter and capacity. So we're obviously going to delve much deeper. There's a lot of things under the surface that I find fascinating, and I hope that I can kind of convey that fascination with each of you so that you can appreciate the nuances for contractual agreements. The other kind of big picture thing that I would like for everyone to kind of consider is that ultimately trying to make a determination if an agreement is enforceable or not. That's something that's done in a judicial venue. So that's something that a judge does. If you're handed a contract and you're told to sign this, and maybe you feel like, well, I don't have a choice, I need to sign this, for whatever it is. It could be to buy something, it could be to lease an apartment, it could be an agreement not to compete. There's so many different ways in which contracts can kind of be put in front of you. Just because you sign something does not necessarily mean that it's enforceable. That's ultimately up for judicial determination if it gets litigated. So, I think most of the time, when someone is handing you a contract, I would hope that it is a valid agreement and that once it's properly executed, it is binding on both parties. But do just always kind of understand that in the back of your mind that, just because you sign something does not necessarily mean that it's enforceable. I've seen instances where parties have said, here, sign this, and they want you to think that it is legally binding, so that, they're relying on your kind of fear of the judicial system that, you're going to perform. When in reality, if you challenged it and said, well, okay, if you're going to sue me, and we'll let a judge decide if this is enforceable or not. A lot of times those parties realize that what they've done is they've kind of overreached. So again, I just kind of say that as a cautionary tale. I think most agreements are valid, but there, I certainly have seen my share of instances where, again, the agreement's not valid. So, even if you don't have a valid agreement, if everybody performs, then everybody performs, and it's not an issue. But do kind of keep that in mind. Okay, in terms of areas where we get contract law, because obviously in our common law system, there has to be some sort of legal framework that provides, the structure in which to kind of flourish whatever area of law that we're kind of looking at, and in this case, contract law. So certainly case law is an optimal source as a place where we get a lot of contract law principles. So, when we say case law, instantly think, law made by judges, as they hear cases. Because contract law was made up with common law courtroom, in terms of that type of venue by individual judges, they apply rules to resolve disputes before them. And as they kind of fashion unique remedies for unique cases, then that becomes part of this body of case law that gets applied in a greater sense for contracts. One of the things we'll talk about when we get to the chapter on consideration, most people think of consideration, in the form of like, okay, if I give you money, that's my consideration. If you give me a physical product, that's your consideration. Maybe you perform services, maybe I'm hiring a pool company to clean my pool. And so, the sweat of their labor, that's consideration, and those are all examples of consideration. But what about a situation where if someone has a legal right to do something and they voluntarily agree as part of a contract not to do something that they are entitled to do? Is that consideration, the idea of giving up a right to do something? And from the early part of our nation's history, that was not considered consideration. There's a case in the 1890s called Hammer v. Sidway that I'll talk about when we get to the consideration chapter, just as kind of like a preview of things to come. And in that case, it was a nephew and an uncle where the uncle had kind of, promised the nephew, if the nephew gave up, gambling and drinking and hanging out with like a rough crowd, things that the nephew had a right to do under the current law in the 1890s in the U.S. If he gave that right up, the uncle would give him a large sum of money. And so, there was a case that kind of emanated from that agreement. And that's what the judge had to decide was, is that a form of consideration that we're going to say now exists? But in the past, previous judges never thought of consideration like that. And so that's one of the great things with common law is that, we can kind of encounter new situations or novel, things. And a judge can say, look, we haven't dealt with this before. This is truly kind of like uncharted territory. And because of that, we can fashion, hopefully, an agreement that will, become, again, part of the greater body of contract law. In addition to case law, we also have statutory law. And so Later in the course, we're going to look at a body of commercial law called the UCC, which is an acronym for the Uniform Commercial Code. We're not going to be looking at it yet, so don't worry about if you're not familiar with that. But in this course, we look at one of the articles of the UCC, Article 2, which involves the sale of goods. And so that is statutory in nature. So if you're a merchant and you're selling things, a lot of how you can, what you can do or cannot do through contract, the UCC will provide coverage for. There are other articles or sections of the UCC. We don't really get into that in this course. We get into that in greater detail in business law too. Anyway, so whether it's whether it's federal or state law, that's an example of how through statutory mechanisms such as, Congress or state legislatures, the rules that they create through law, that has the impact of being a source of contract law. So contracts can be classified in a number of ways. And so, on one level or one dimension, you can kind of consider them to either be formal versus informal. So formal, what by the very label, what is required are a lot of strict, formalities or particularities in order to say that we have satisfied, the complexity of this type of an agreement. So negotiable instruments, where maybe you're acquiring, like let's say you buy a car, but you get it financed. If you have a promissory note and you discount the note and sell it, to like an investor. Anytime you have an instrument that is negotiated for, like, let's say some form of consideration, that would be an example where there are some formalities that are required. Contracts of record. If any of you have either purchased real property like a home or land, or if, when you do so in the future, there's a lot of strict requirements that have to be followed. Anything that's not considered formal by default gets lumped into informal. So, your transactions at the grocery store, for example, that's an informal classification of an agreement or contract. You can also have contracts that are considered either express or implied. And so express are when you actually have, words that could either be spoken or written. You can have verbal agreements. I always advise against verbal agreements, even if, there's a number of times where they are valid and enforceable. The problem is that when you have two parties that maybe remember things differently, how do you prove which party is more believable? It's better to have something in writing. Even if the writing is not very well done, at least you have something written to refer to. But that would be an example of an express agreement, whether it's spoken or written, so there's actual words. Implied are where, we basically kind of create that contract or agreement because we're trying to avoid maybe an injustice. Another concept that we'll look at in future chapters is something called unjust enrichment. And the idea there is that, if we don't intercede and pretend that a contract existed, then some party is going to suffer and another party is going to be enriched, and it's going to be considered unfair in certain situations. And so because of that, that's where we say we're going to imply and pretend that a contract existed, when in reality it didn't. So again, these are just different types of classifications. In addition to formal and express, there's also this continuum of contract classifications, specifically being valid, voidable, or void. So valid agreement, that's easy. It's binding. You satisfy, you checked off all those boxes. You have offer, acceptance, mutual consideration, lawful purpose, and everyone has contractual capacity. So that would be a valid agreement. Void at the very other end of the spectrum are contracts that a court will not enforce. They never will. So maybe it's a contract that involves illegal items. Obviously no court is going to enforce that. Another example of a void contract, and this is a very nuanced area of the law, if you ever get a guardianship over someone, let's say the common example is as someone gets older, maybe it's a parent, grandparent, and as people get older, they suffer from a variety of ailments, physical and mental. And let's just say that for whatever reason, it's not safe for them to live alone and to take care of themselves anymore because of their age. And so sometimes a family member, and it could be a younger sibling or a child if that's appropriate, goes to court and actually seeks to get a guardianship over this elderly person. That is a really kind of like a very powerful request of the court, because you're essentially taking away any rights to make decisions by that person and giving it to whoever is asking to be the guardian. So if I have a guardianship over, let's say my mother, I would then have control over where she lives, what she can do, what she can't do, what she can buy, what she can't buy. So if for some reason, she figures out a way to buy something without my authorization, that agreement is considered void per se. There's no way, even if it's a great deal, it doesn't matter, because I'm the guardian in that hypothetical situation. I would be the one that would be tasked with actually being the person to buy this on her behalf. Avoidable, and there's several cases. This is kind of like a muddy area of contracts where it depends on certain situations, and if you're the party that is the one that could potentially suffer, then we give some parties the option to say, I don't want to be in this contract. To give you one example, again, we'll go through this in more detail in future chapters. If you're a minor, so if you're someone that's under the age of 18, so you're 17 or younger, if you are contracting for what is considered a necessary, so that a necessary is like food, shelter, medical care, you cannot avoid those liabilities through contract. So you're kind of bound by them, even though you could be 16 years old. If you're contracting for anything else, though, if it's not a necessary, then the minor can treat that agreement as voidable, meaning that it's optional. If they want to go through with it, they can, but they don't have to. And so that's a very powerful, very significant tool or leverage that a minor has when they're purchasing from whoever the adult is. Whether it's a casual transaction where you're buying from an adult that you know in the community, or if you're going to a business. And again, I'll go through some specific examples, but that's one example of several that exist where you could say the contract is voidable, meaning that if the party that is likely to suffer from the agreement, if they so choose, they can say, I don't want to perform. And so I will give back whatever consideration I received, and whatever consideration I've given, I expect that back. So that's voidable. You don't have to, it's an optional type thing. Some other types of contracts that the author discusses in this chapter. So you have option and right of first refusal contracts. The idea with an optional contract is that you're giving one party the right to enter into essentially a second agreement at some future point if they want to. They don't have to, though. The best example that I've seen, this involves where you're renting a piece of property, so let's say a home, and it has contained within that rental agreement an option to purchase. So maybe you don't have the funds today to purchase, like let's say this home, but you work out with the seller, look, let me rent this for 2 years, and then within that 2-year window, if I can get enough, capital together, and if I can get this financed, then I will purchase the home in question. So that's a great example of an options contract. The right of first refusal, the most common time when I've seen this is in more rural areas where you have adjacent landowners who own, multiple acres of property, 5, 10, 15 acres or more. And sometimes neighbors will enter into this type of right of first refusal that, if I approach a neighbor and say, look, if you ever decide to sell your land, give me first dibs at it. And so, if you want to formalize that agreement, that's fine, but it could be verbal. And so, all that the other party has to do is, if they decide to sell, they come to you first, and you're either able to purchase it or not. If you're not, then they move on and they can sell it to anybody at that point. But again, some unique situations that are applied regarding options and right of first refusal contracts. Quasi-contracts, here, this is what I was kind of mentioning a few minutes ago regarding unjust enrichment. The law regards it as unjust for a person to receive a benefit and not pay for it. And what we're looking for here, and I'm going to go through an example on the next slide, but the elements that you would have to demonstrate If you're the party seeking, some sort of remedy because of unjust enrichment, there has to be some kind of benefit conferred on who you are bringing into court, so the defendant, the person that you filed a complaint on. The defendant had to know of the benefit. You can either demonstrate either actual knowledge, or you could demonstrate what's called constructive knowledge. And again, I'll explain that through example on the next slide. And then you also have to demonstrate that it would be unjust if the defendant could retain the benefit without payment. And so if you can satisfy all three of these, then what that means is that the judge in question will pretend an agreement exists, even though no agreement did exist. But it's a legal fiction. That's really what we're kind of getting at with unjust enrichment. So in this particular case, who pays the piper? What you have here, you have adjacent landowners, and you have Frank and Elmer. And so Elmer made improvements on his land. And if you're a landowner, or one day when you become a landowner, anytime you do anything on your property that potentially increases value, that's going to increase your property taxes. So the tax assessor, and that's done on a county by county basis. The tax assessor made a mistake about the location of where the improvement was made, so that instead of applying the increase in property tax to Elmer, he applied the property tax to Frank, the neighbor. And, for 3 years, Frank ended up paying more in property taxes and when it should have been Elmer, and so I don't have the amounts here, and I don't recall what these specific amounts were, but let's say it was $1,000 a year, so over 3 years, it's $3,000. So that's not insignificant. And so, sometimes students will ask me, well, how come Frank didn't know this? And if any of you, have ever owned property, or one day when you will own property, if you have a mortgage on your property, a lot of times you pay your mortgage monthly, and your mortgage handler will pay your property taxes for you, because they fold in the value of your taxes in with your mortgage payment on a monthly basis. So sometimes, you'll receive the notice, but you might not even look at it. You're like, okay, well, my mortgage takes care of my property taxes, so I don't have to worry about this. So Frank didn't really notice this. The key thing, though, for Elmer, even though Elmer probably did not know of the mistake, the fact that, every property owner on an annual basis receives that notice of, these are your property taxes for the coming year, that's his actual and constructive notice. So even if he didn't read it, we're going to pretend that he should have, because technically you should. Anyway, so, I always, in class, I try and make it a fun kind of conversation, where it's like, if you're Frank, what do you do? It's like, well, Frank could, go down to the tax assessor's office and say, fix the mistake, which they will do that. They will fix it. The problem, though, is that when Frank says, can I have a refund? They're not going to give him a refund. They never will. If he asks for credit, because, if he says, well, I paid extra for 3 years, will you give me credit on the next 3 years or something? Again, the tax assessor will not do that. And so you're kind of stuck then. It's like, well, I got to go talk to Elmer. So go talk to Elmer. And Elmer, if Elmer's nice and says, look, I see the mistake was made, I'll pay you, give me, a few days, whatever, I'll get the money together and I'll pay you in full. That would be a great neighbor. But we know that's not necessarily how the world works, having great neighbors. So if Elmer says, that's not my mistake, I'm not paying you, then that leaves you no recourse, but you would have to sue them. And this is where you have to kind of, going back to the previous slide, be able to establish, that there was a benefit that was conferred, that the defendant knew of that benefit. And if you didn't fix it, then the defendant, in this case, Elmer, would kind of get away with not having to pay property taxes that increase over a 3-year period. And so what the judge will do is pretend to say that, what I'm going to do in this case is that I'm going to pretend that Frank and Elmer had a contract, that for 3 years, Frank was going to pay that increase in property taxes, and at the end of the 3 years, Elmer was going to pay him back. Now, that agreement never existed because, no one knew of the mistake for 3 years. But that's how the court rationalizes this idea of unjust enrichment. And that's the way in which, you can kind of avoid having this problem where, because government's not going to give you money back. Because I mean, the tax assessor is going to say that money has already been spent. We take property taxes and we give all that money to fire departments, to school teachers, to police departments. It's spent. We don't have like money just sitting around. And you could see that if we didn't have this theory of unjust enrichment, there would be no relief mechanism if Elmer decided he wasn't going to pay. So anyway, hopefully, after you read this chapter, you have a greater appreciation for this, at least first initial kind of conversation of what it takes to have a binding and enforceable contract. Remember the elements. You have to have an offer, you have to have acceptance, you have to have consideration, mutual, both ways. It has to be for a lawful subject matter, and everyone has to have what is considered to be legal or contractual capacity or an understanding that a contract exists. If you have questions like normal, please reach out to me anytime, but I thank you all very much for listening to me and watching this video. Have a wonderful day. Thank you.